Welcome back to Courtroom Chronicles. Today's docket opens with the case of Stephen Howard, a defendant who swears he's innocent of alcohol use. But the lab results tell a different story. And wait till you hear how the judge reacts when Stephen tries to play smart with the environmental excuse. Let's dive in.
Against Stephen Howard, 24F24311. Come on up here, Mr. Howard. Ms. Tessino, your name?
Oh, Tessino?
He's saying environmental. Pleads not guilty. I'm entering a not guilty plea form. And you still, your name again, sir?
Stephen Howard.
You still wish to waive your right to a lawyer?
Yes, sir.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give you hold true self you got.
Yes, Your Honor.
All right, go ahead.
So I do have the lab results here. They're dated, it's from August 5th, 2025, and the ECG was confirmed at 576 nanograms per milliliter and ETS at 441 nanograms per milliliter.
That's the confirmation test,
That's the
right?
confirmation test.
Did you order a confirmation test?
Yes, so
Can you explain to him what a confirmation test does with regard to environmental factors?
yes. So the instant cuff would rule out anything that would be considered like a false positive. So when they send it to the lab, it breaks the sample down further for the ETG. So your ETG was the 576 and the cutoff is 500. And then what they do is they break it down and confirm it again and do the ETS. Your levels for that were 541 and the cutoff is 125.
Yeah.
So the test is pretty much stating that your body metabolized something.
Do you have any questions of her?
No.
Notice the judge's tone here. He's trying to give Stephen a fair chance. But the moment Stephen hesitates, it's game over. The judge can already sense he's not being straight. And in a courtroom, hesitation can sound a lot like guilt.
I think.
Hang on. I just want to know, first of all, do you have any questions of her? You said no, right? If you do, you can.
I understand it, but
Sir,
I didn't drink it.
sir, I'm going to swear you to an oath if you want to testify. If you want to testify, I'm going to put you under oath. So you can't just talk. If you tell me, Judge, I don't have any questions, but I want to testify, I'm going to swear you into an oath. And then I'm going to let you testify. You have the right to remain silent. You don't have to say anything.
Alright.
Do you want to testify or do you want to remain silent?
I guess I'll remain silent.
All right. Anything else?
No, that's it, Your Honor.
Do you have any argument?
Yes, sir.
We find you guilty as charged. That confirmation test rules out any environmental factors. At least you didn't go so far as to test or to testify under oath, which I'm going to find you guilty after hearing. Don't come in and lie to me again, okay? Please don't come in and lie to me again, all right? I've seen this little rodeo before. You follow me? Don't come in and lie to me again. How's he doing with everything else? I mean,
Everything else, I mean, honestly, he's doing really well. I mean, we just talked
how
about.
often is he testing right now?
Right now, he does live in Monroe County, so he does drive a bit right now.
Despite everything, listen to the compassion here. The probation officer admits Stephen's been doing well, working, attending treatment, even paying fines. It's a reminder that sometimes one bad choice doesn't erase progress, but lying about it definitely hurts your case.
He's on bi-weekly, and then he is attending treatment at Salvation Army, and they do randomly test him as well.
I got tested on Monday.
I don't know, my concern, I guess, with increasing his testing here, I don't want to set him up to fail. If we could do like a hybrid with Salvation Army and DNA, they do send you the results.
What do you think? You tell me what you think I should do.
You know, Stephen has come a long way. I wish he would be honest. You know,
I know, I didn't appreciate his dishonesty here.
he did get a job since you've seen him last. He does seem to be genuine in wanting to be sober. He's going to meetings. He has a sponsor.
I paid off my fine.
Wait, let her finish.
Yeah, he paid off his fines, but everything else is completed. I mean, really, he's just maintaining, as far as testing and treatment.
Right now, he's testing bi-weekly.
Correct. And then Salvation Army tests him once a week, when he's there for his appointments. I did speak to his therapist.
So you want to just use those test results?
I just would hate to, I don't think he could comply to me once a week here.
So you want me to have, defendants to test weekly with Salvation Army? They to forward results to us, right?
Correct, and then his therapist did increase his meetings, from my understanding, that he's seeing her once a week again.
Continued treatment, pay costs of $100, serve 8 hours of community service by September 21st, test weekly with Salvation Army, and they will forward the results to us, but you have to test weekly with them, okay? You have the $100 to pay?
I do, sir.
Okay, pay
I'm
that,
not cash.
pardon?
I have my debit card with me.
That's fine. Pay now, and we'll go from there.
Okay, sounds good, thank you.
Moradiglio Fernando Sanchez, 255-414-415-027.
Se llama el caso del señor Sánchez, Diego Sánchez, número 25 y 415027 OT.
Morning, Your Honor. Mike O'Connor, representing the defendant.
Ms. Villarreal, raise your right hand. Thanks for standing in. You solemnly swear or affirm that you will make a true and accurate translation between the court and the parties.
Yes, I do, Your Honor.
Tell me your name, sir.
Dígame su nombre, señor.
Diego Sánchez.
Diego Sánchez.
Look, I'm not gonna keep paying for Spanish interpreters when you don't show up here.
Mire, señor, yo no voy a continuar a estar pagando por intérpretes de español para que usted no se presente aquí.
It's not happening.
No, eso no va a suceder.
It's just not happening.
No va a suceder.
The interpreter was here July 30. You didn't appear. You didn't
El
appear.
intérprete estuvo aquí el 30 de julio. Usted no compareció.
August 13th, you didn't appear.
El 13 de agosto tampoco usted compareció.
August 21, you came in. We set it again for August 27. You
El
didn't.
21 de agosto usted vino, le dimos la fecha nueva para el 27 de agosto.
I hope you have money in your pocket.
Ojalá que usted tenga dinero en su bolsillo hoy,
I'm not going to put up with this nonsense.
porque yo no voy a tolerar estas pocas vergüenzas.
This is absolute, unequivocal nonsense.
Esto es absolutamente unas pocas vergüenzas.
I don't know why you think you can do this.
Yo no sé por qué usted piensa que usted puede hacer esto.
You must be running the Pentagon at a minimum.
Es que usted está encargado
If
de
it happens again, setting a cash bond you won't be able to make, and I'm going to set this case in about 10 months. Do we understand one another?
Así que yo le voy a dar una fianza en efectivo y voy a darle una fecha en unos 10 meses. ¿Comprende usted?
Do you understand?
¿Usted comprende?
As it is now, it's 3,010%.
La fianza-
3,010% will be your cash bond. You're going to have to post $300. I hope you can, but I'm not going to keep doing this. Do we understand one another?
Señor, yo le voy a dar a usted una fianza de $3,000 pagable el 10% para que pueda continuar a estar libre. La tiene que pagar en efectivo, así que 300 que me tiene que pagar en efectivo, porque yo no voy a seguir con estas pocas vergüenzas. ¿Usted me entiende a mí?
Sí, señor.
Did you
Yes.
say yes?
Yes.
Totally and completely?
Usted completamente, totalmente, ¿usted me comprende a mí?
Sí, señor.
Yes.
$300.
Can he post $300?
¿Puede usted pagar $300 hoy?
Sí, señor.
Today.
Yes.
Pull this nonsense again. I promise you, you'll be sitting in the back for a long time until I get around to handling the case when I feel like it.
Si usted vuelve con estas pocas vergüenzas, se va a estar sentado en la parte de atrás de esta sala y cuando yo decida que quiero llamar su caso, es cuando lo haré.
New pretrial date, Lisa. You
September
saying
10th at 10:30.
September 10 at 10:30.
Su próxima fecha para comparecer es el 10 de septiembre a las 10:30 de la mañana.
And by the way, you better save your money because you're going to be paying for these attorney fees or interpreter fees.
Y usted empieza a ahorrar dinero porque le vamos a pedir a usted.
This is pure courtroom fire. I'm not putting up with this nonsense, the judge says, and slaps down a $300 cash bond. You can feel his frustration boiling over. This isn't just about one missed hearing. It's about respect for the court. What do you think? Was the judge too harsh or totally justified? Comment your thoughts below, hit subscribe, and stay tuned for more real courtroom moments caught on camera. Only on Courtroom Chronicles.
Joshua Edward Schaefer. 215-235-321A.
Against the record,
Welcome back to Courtroom Chronicles. Today's case centers on Joshua Edwards Shaver, a man whose driving record is anything but ordinary. What starts as a simple license violation quickly spirals into a confusing timeline of jail time, suspended sentences, and a judge who's trying to make sense of 3 years that don't quite add up. Buckle up, because this one turns into a verbal tug-of-war where every date, charge, and explanation seems to contradict the last. Let's dive in.
House Counsel Attorney Mike Bolden, P-55 Bolden, second on behalf of Mr.
Your name, sir?
Josh.
He's going to plead to no ops. They're going to dismiss the suspend. True?
Correct.
Is that what you want to do?
Yes, sir.
If you plead guilty here, the possible penalties are up to 100 fines, 90 days jail. Costs are all those. Do you understand that? Did you sign an advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand?
Yes.
All right. You understand everything?
Yes.
To the charge, don't valid operator license on your person. How do you plead?
Guilty.
On the 24th of March of 21, were you in the city of Flat Rock County of Wheeling operating a motor vehicle on Telegraph near Wheeling at roughly 3:37 p.m.?
Yes.
Do you have a valid license with you on your person?
No, sir.
Are you on probation or parole? Were you on probation on March 24 of 21? Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
That's
Plea is accepted, the no ops, the suspends dismissed. I'm ready for sentence. Anything you'd like to say? Where's he been?
Yeah, and that's exactly where I was going. So in my notes, Judge, about early.
He lives on West Jefferson in Brownstown. Right?
I'm going to explain. About early 2022, he went into jail, county,
I'm sorry, what?
county jail.
When was that though?
Sometime in early 22. He picked up another offense while in the facility, which put him on a discharge of January 25. He walks into
Of what year? 23 or 22?
25, January 25, he comes out, so he did 3.
He did 3 years?
There was some, hold on, that's okay. We're recording, so we have to make sure we don't talk over each other. I'll Judge, he did 3 years county time because he had an offense while in the facility.
What was he locked up for 3 years for?
Here's where things start to get messy. The attorney claims Shaver's been in and out of jail since early 2022, nearly 3 years total, including a fight that left 2 correctional officers injured. That's a major red flag for any judge. The defense is trying to show that Joshua's already done his time. But the problem is, the timeline doesn't quite match. When your record starts blending fights, suspensions, and conflicting jail dates, the courtroom patience wears thin real fast.
I went in for driving on suspended, and they gave me 6 months, no fines, no costs, no probation, no nothing. And while I was in there, I got to a fight, and 2 guards got hurt, and I got charged for that.
So he came out in January of 25, he's turned himself in to take.
You got in a fight with corrections officers?
No, sir. No,
They just got hurt, they were.
Yeah, it was, I got into a fight with another inmate, and the officers got hurt. One dislocated their shoulder, and the other one busted their head on a bed.
So that's where he's been. But Judge, he did walk in.
In August. Why didn't he walk in January? Why didn't you walk in January?
I honestly thought this was taken care of. It's been a long time, and I swear to you, sir,
We took,
I could have swore it was taken care of. Due jail time, I thought it was due jail time. It was taken care of. Like a concurrent,
how could he have, what month did you go in what year?
I'm not exactly sure the month, sir.
Here's early 22, Judge.
Lives on West Jefferson?
No, I moved to maybe Michigan.
Do you work?
Yes, sir, backyard products. I'm a machine operator.
What else? Anything else?
But Judge, you know, as we get older, we change. He realized that he had to take care of this. He's here. He's ready to take responsibility. I will note, Judge, I did see a 2025 police report, so I think that he may have another DWLS coming down the pipe.
So you got 6 months on a driving suspended?
They offered me to do certain time on it.
Hang on a second, let's slow down. Where were you that caused you to get 6 months on a driving suspended?
No.
So on a drive while, was it drive while suspended or a drive while revoked?
You actually helped me break that cycle by lifting the suspension I had on my license.
For the insurance, right?
Oh, geez. He's got a GB,
Well, one was pled down to a misdemeanor, Judge.
I know, but the offense date was July 13 of 23. I thought he was in custody in 23.
I think that was the offense while he was in custody is when it happened. So he was a ward of the state when that, or the county when that happened.
Well, he just told me he got 6 months out of Monroe, right?
That was the original charge.
I get it.
And then while I was in there, it was like.
Well, I got an offense date for, pull him up, please. I don't see him. It's, you gotta put in his first name. It's Joshua. Look at number 4 and look at number 4. This was out of Brownstown. You were charged with assault. Can you go down? Down a little more. It was a domestic violence from July of 23.
Okay.
Where were you then? It's out of Brownstown. You couldn't have been in
I went to Wayne County, Brownstown took me to Wayne County, I did.
Listen to what I'm telling you. You were out of custody in July of 23. True or false?
True.
Well, I thought you just told me, you guys just told me he's in custody for 3 years.
Yeah, his story's not.
Now this is the breaking point. The judge's tone shifts from patient to skeptical. He's hearing two conflicting stories. One from the defense saying Shaver was locked up for 3 straight years, and another showing an entirely new assault case from 2023. The judge's math doesn't lie. You can't be both in custody and committing new crimes on the outside. This kind of contradiction doesn't just confuse the court. It can crush credibility in sentencing.
No, 22 to 25, that's why.
This was prior, you said 21, the charge is in 21. You asked where I've been lately, that's where I was at lately.
The ticket was in 21.
Yes,
This ticket was in 21.
yes.
And my inquiry is as to why he didn't show up on this case, like people that tell me
22.
that he's been in custody. He was in custody until January of this year. He was in custody for 3 years. This offense out of Brownstown happened in July of 23. If you were in custody for 3 years until January of 25, I promise you were in custody in July of 23.
Right.
That was only 18 months before you were released from the Monroe County.
Sir, the ticket was in 2021. After that, I went to jail when I got that ticket. That's what I was trying to explain to you.
What he's saying, what the judge is saying is, where have you been that you didn't take care of the file?
Well, I was in jail, and then now that I got on, I've been working. I'm trying to take care of it now. That's
Judge, he wasn't in jail in 23, obvious.
You weren't.
I was absolutely in jail in 23.
Well,
I went to Brownstown, took me to Wayne.
Hang on one second. Lisa, am I missing something? Can you tell me the offense date on that? I see it was arraigned on assault with intent to do great bodily harm in July of 23. Judge Hessen arraigned him
Still on probation.
to the Wayne County Circuit Court, right?
Yes, sir.
When did that offense happen?
And 23, July.
Well, then you couldn't have been in custody in 23. It happened in Brownstown is all I'm saying to you.
Oh, yeah, I don't know that. I was absolutely incarcerated. I went from the jail in Detroit to Monroe.
Judge, there's no valid reason why he.
All right,
So
let's let it go.
you weren't in jail in you weren't in jail from 22 to 20, because you were out in 23.
That is absolutely incorrect. I've been incarcerated.
Don't start hang on. Don't start pointing your
How can you tell me I'm lying right
Hang on a second.
Sorry, I
Don't
apologize.
start pointing your finger at me. I'm trying to get.
No, I was putting in the page, sorry.
We're just have a casual discussion and hold your position.
Can you
Seeing something that doesn't add up, that's all.
Okay.
Can you tell me what the offense date was on that GBA? It's a 23 case. You couldn't have been in custody. It was a 23 case out of Brownstown.
I swear to you, sir, I'll give you my probation officer's number. You can call it right now, sir. I was absolutely incarcerated.
Unless that was one of those that happened 2 years earlier. Can you make heads or tails out of that, Lisa?
The way my probation.
Hang on one second.
Hold on.
Are you talking about the felony charge?
Yeah, 23B715135. I'm trying to
Yeah.
find you.
It's showing an offense date of July 13th of 23.
Right.
So
So if there was an offense date of July 13 of 23 out of Brownstown, you couldn't have been in the Monroe County Jail.
I went to Brownstown, and then from Brownstown, I went to Monroe because I had a warrant out of Monroe for the driving unsuspended. They offered me 6 months,
Okay.
and within that 6 months, I got in trouble. They got into a fight and hurt the officers. Well, the officers got hurt. I did not hurt them.
I believe you, but you
is it possible that?
you acknowledge that you weren't in custody at the time of this case out of Brownstown that allegedly happened on July 13 of 23, for which you're on probation now. That's all I'm asking.
Yeah.
Okay.
Yeah.
Well, you guys were telling me that you were in custody for 3 years until January of 25. Now, I don't have to be that good at math. If you were in custody for 3 years and got out in January 25, that means sometime around early 22, you were in custody from there until January 25. That's all I'm saying. I'm not arguing with you.
Right, is it possible it was 23 to 20?
I've heard enough. Let's move on. Let's move on.
Got it.
Anything else?
No, Judge.
Anything else?
Fines and costs. It's an old case. I explained to him this needs to be cleaned up.
If he was in custody for 3 years, I was going to give him credit for time served. That's why I was belaboring the
Thank you,
point.
Judge.
Anything else?
In the end, Judge keeps it balanced. No extra jail time, but over $385 in fines and costs. Joshua promises to pay half immediately, showing at least some accountability. This hearing reminds us how messy timelines and miscommunication can complicate even simple traffic offenses. From confused dates to conflicting stories, the courtroom stayed tense till the very last second. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts below, and subscribe for more jaw-dropping courtroom breakdowns, because every case tells a story, and this one was wild.
Concord versus Amanda Mount. Amanda Mount versus Concord, 2501975. Mr. Gallup.
Good morning, Your Honor. Creighton Gallup, P63002, on behalf of Concord Cooperative.
Welcome back to Courtroom Chronicles, and buckle up, because today's case is one wild ride through endless motions, missed agreements, and sheer courtroom chaos. Judge after judge has tried to settle this mess, but somehow, new motions just keep showing up. One side says it's all handled, the other claims misconduct and missing repairs. The real question? Who's stalling the process? And why does this case refuse to die? Let's dive into the hearing where Judge Gallup tries to put an end to the madness once and for all.
Mount?
Amanda Mount.
I'm at a loss as to what is going on here. I thought the case was settled, and I'm getting motion after motion after motion, and when people are done filing motions, they're filing more motions. I mean, everything from certifying a class to now motion for protective orders, sanctions for abuse of process. I mean, I don't know what to say anymore. Are you guys settling this or not settling this?
Your Honor, if I could interject here, we have mediated on at least 2 occasions with Judge Hessen, and I'd like to say on a personal note, I appreciate her efforts to try and get this thing resolved. I have submitted to Ms. Mount, this is on a second occasion, a revised agreement that I believe encapsulated the final terms that we had worked out with Judge Hessen after doing a walkthrough of her unit. First one I was denied access, but Judge Hessen facilitated a second inspection. We went in there, and we believe we'd worked out a deal. I have provided that to Court Administrator Jen on Friday and a copy to Ms. Mount. I have not heard back from Ms. Mount as to whether those terms are acceptable or not. So the ball is in her court. The only motion that we have filed is after the 14th motion was filed by Ms. Mount last week. We just had to put an end to this. We just can't keep up with these motions. A lot of these are evidentiary in nature, and they're not.
These kinds of things. You can raise this at the time of the hearing. Motion to strike police report and certain board member statements as inadmissible, misleading, and tainted by conflict of interest. Motion to preserve rights, objections, and defenses. I mean, I don't want to be rude. It seems like you're enjoying playing lawyer here, and that's okay. But at some point,
This moment captures the exhaustion of courtroom bureaucracy. Imagine being the judge and receiving pile after pile of motions for a case you thought was finished. It's not just disorganization, it's tactical chaos. Sometimes one party files so many motions that the other side simply can't keep up, forcing delays. Do you think this is a genuine pursuit of justice or a strategy to drag things out? Let us know in the comments.
I'd understood the case was settled. That's what I'd understood. Now I have seemingly I got stacks of stuff here. And I don't know what's happened. Can you just tell me what the basic tenet of the conditional dismissal terms were, Mr. Gallup?
If the court's comfortable with that, because I do know that she had filed a request for a waiver of the jury trial, and I don't want to cause any problems with you if you're going to be the jurist on this one, Your Honor. I can tell you it was a conditional dismissal in general that had arranged for some terms that she would be able to stay so long as the general rules had been followed. I don't want to get into all the specific details, but Judge Hessen worked very hard with both parties to get some middle ground here. I thought this was resolved. I've just not heard back from Ms. Mount from the proposal that was sent to her last week, which is the second draft, which incorporated newer terms for her protection after the inspection that we'd done with Judge Hessen.
Well, do I dare ask what the new terms were?
No, it specified certain items that we were going to repair in her unit that were basis of her counter complaint, things that she'd said that had been lingering that had gone unaddressed. It was all going to be taken care of here within the next 30 days.
I don't know what to say. I don't know what to say. I thought it was settled. Did they change something?
No, the habitability was settled, and not the misconduct.
Here we hit one of the case's strangest turns. Police reports, conflicting statements, and witness contradictions. None of it's officially in the record, yet it keeps being brought up. From a legal standpoint, this is dangerous. Courts can only rely on admissible evidence, anything outside that can't be used to make a ruling. But emotionally, it fuels distrust and drama. The tension here isn't just legal, it's deeply personal.
Remind me, what specific misconduct?
Withholding my work order, filing a police report when I wasn't even there.
So
And it all started after I started enforcing my shareholder rights, for withholding a work order.
Can you elaborate on that, Mr. Gallo?
Yeah, she keeps referencing these police reports that are not a part of the court record right now, and that's the basis of one of her motions. I really don't know how to respond to it. It's not a part of the court record yet. She's insistent on having a police report.
File police reports.
I had to do it. There was at least one or two police reports, one of which, when the police were contacted after there'd been a threat made about the site manager, she threatened that she was going to beat her up. And I believe there was at least one other police report sometime where she believes there's conflicting statements from maintenance guys that she wants to call as witnesses. I don't think there's any probative value here, that nothing's been submitted to the court as a part of this. And if this is something that would need to be excluded or included as a part of an exhibit at trial, there are limiting motions and processes that would be handled for something like that. It's very preliminary that she would raise this issue right now. I don't think it's relevant. Regarding the unit itself, she's made claims that her work repairs went unanswered. I think the court knows this. This has been part of the record. There were some delays due to COVID.
Yeah, you know, but that's not right either.
And that's why, and Your Honor, and we have worked diligently with the defendant, and we have worked with.
Do you have time limits in there and the conditional dismissal as to when all these repairs are going to take place?
Yeah, they were already supposed to have taken place last month, but she wouldn't let us into the unit. She changed that. Now it's scheduled, judges, but we've rescheduled it pursuant to new agreement to the end of September, because it's going to require her and her family.
Slow down. I can't hear. I can't pick up two of you at the same time. You think I can hear you both and comprehend you both? Was a date set for them to come in?
Yes.
Did you let them in?
The first time, no.
Why?
Because I would prefer an extra set of eyes, because.
Did you tell Judge Hessen you weren't gonna let them in the first time without her being there?
No, but
Why did you not let them in then?
Well, because there's bigger issues.
So they're seeking to have you removed. And it sounds to me like you're winning. That's what's befuddling. Hang on. It sounds to me like you're winning. If there's a conditional dismissal, Leonard, they have obligations, you have obligations, but as far as I can tell, you've won.
I understand that, Your Honor, but a conditional dismissal, I've done nothing to deserve a conditional dismissal. I did what I'm allowed to do.
Well, doesn't the conditional dismissal set forth that they're going to undertake all this work? And that there's to be no further violations by you, and as long as there aren't, that will be, the case will remain dismissed? Look, if you guys don't want to settle it, I have no issue with that.
Yeah.
All I know is I thought it was settled. And it seems like every single or every other third day it just seems like I get motion after motion. I come back from a conference, I got motions after motions here, and I'm thinking, what is going on?
This line hits hard. Every motion, every hearing, every delay, it all costs money. And in cooperative housing cases like this, those legal costs don't just vanish. They're often billed back to members, meaning everyone pays the price for the feud. It's a powerful reminder that in civil disputes, winning on paper doesn't always mean winning financially.
I thought we were waiting for a conditional dismissal. Did you graduate from college?
Almost.
Maybe you should go to college and go to law school.
It's not my intention. I have stage fright. Like, this is not what I want to do, but I do know my rights, and I know I didn't do anything wrong. And.
All right. I understood it was settled. Is there anything else I can do to try to resolve this? You're right. If it's not a jury trial, I'm going to listen to the facts, and I'm going to make a determination as to what the facts are and apply the law.
Your Honor, as far as I'm concerned, the ball is in her court. We provided a proposed agreement, a revised agreement. This is at least the second draft that we've given her last week, and I've not heard from her. So if she's telling the court and me today that she's not interested, we got to put this on the litigation track. I'd rather resolve it if we can. My clients come a very long way from where they were at, and it's just very frustrating that all this treasure's been spilt on this. These costs are getting assessed back against the members themselves. This is expensive stuff, so we just need a Fisher cut bait. I'd rather resolve it, but we have to go to trial. So be it.
Okay. I don't even know where to start.
Well, I can't hear very well, Your Honor. Did Ms. Mount, is she definitively saying she is rejecting what was provided to her last
The
week?
way it sounds to me.
Okay.
I can tell you you're in the wrong court if you're talking about certifying this as a class action. Then I have other issues that I need to address, like well, how long are you going to be gone on vacation?
I'll be back the 17th, Judge. We do have a preliminary date for the motion that we'd filed, the motion for the protective order. The court had given us October 6th. I know the court doesn't want to put this out further than necessary. I've not received a response to her motion. We just filed it last week. So obviously she would have a little bit of time to respond.
I don't need to decide anymore. There's so many here.
You've only.
I've got packet after packet after packet.
You've made decision on one general motion, which was her motion to transfer,
Right.
And we submitted an order.
Motion for reconsideration. I got emergency motion for protective order. I've got motion to preserve rights, objections, and defenses. Notice of waiver of jury demand. Police report is inadmissible upon hearsay. Motion to certify and transfer to circuit court. Motion for class certification. I think there's a couple more in here.
There were still 5 or 6 preceding from the first batch that she'd filed that the court has not had an opportunity to rule upon.
I know.
Yeah.
I don't even know. All right. Okay. Okay. Well, if you guys don't want to settle, you don't want to settle. I guess we'll just go forward. I will schedule Jennifer.
Yes, Judge.
A notice going out on all these motions. We're going to set them for October. Was it the 6th that we already set the one with Mr. Gallup?
We gave them the 6th as a tentative date, yes.
Okay. So if, okay, let me see here. All right. So I want you to set forth all motions that are going to be heard on that. I want it, I don't even know. So all motions, you're going to separately list each one.
And Judge, for quick reference, if you look at our motion for the protective order, I believe we listed them all for your convenience. I think we listed them. There's 1 through 14. That should help the court.
There's 14 of them?
I believe it was close to 14 that she filed. We've only filed one motion.
Oh, there was more. I must be getting bad at counting. Motion for reconsideration will be the first one on the list. Set them all for October 16th. Any responses are due by
October 6th.
Register, if you would, by September the 29th. Can you do that, Mr. Gallup?
I believe we've responded to all of those, including the 2 recent ones she filed last week. I think
Match them all up and give them to me, Jennifer. If there's
Yep.
any other ones, you have to respond by September 29th. You likewise have until September 29th, ma'am, to file any responses, okay?
The only other thing I'd ask the court, Your Honor, we've already relied on what we thought was an agreement to get these contractors out there. This is our duty anyway to make repairs. We're going to ask that the court order her to cooperate with any type of necessary inspections in the interim. There are a couple things that need to be done. One is the flooring. The second requires a contractor to come out there and displace them. We'd already made a hotel reservation to put them out. This could.
Hotel reservation? Who out?
Because they're going to be renovating the bathroom upstairs. HUD requires them to relocate. We've already made arrangements when we're talking with Judge Hessen to get her and her family accommodations if they choose to use them, because they're going to have to rip out the bathtub and replace the flooring upstairs. These are the repairs that were scheduled for August that we rescheduled for at the end of September. If we reschedule it again, this may not happen until October, November, and that'll just.
So wait a minute, when are you scheduled to do the work?
29th, September 29th.
Okay, and you paid for a room for Ms. Mount and her family?
They've already made one arrangement. They're making a second one. They're not out of money until she doesn't show up. We can still cancel. My understanding is we're making another reservation for her for a period of a week. It's possibly a week it's going to take to do the upstairs.
What do you want me to order? Tell me what you want me to order.
That she will cooperate with the necessary repairs as proposed in the.
If you're going to complain about them not doing repairs, hang on.
Okay.
If you're going to complain about them not doing repairs, you need to let them in to do repairs,
I
right?
understand that, but my children's stuff has been stolen from the last time, so I appreciate it if I could get them out of the house and do it without them worrying, because they're traumatized from the last time.
From what last
From
time?
our stuff being stolen
When?
from contractors.
When?
When we were out last time in the hotel for 3 months.
Judge, I don't know what she's talking about. We have never had any reports.
What do you want to, I'm not following you. Do you want them in to do the repairs?
Yes, I did. I just, my kids.
Well, I understand, but do you want to take them to the hotel?
I mean, yeah, I don't have a problem. I just, everybody's showing up at the door. I would prefer just to keep them out of it as much as possible.
Well, tell
Because
them,
they're
wait a
afraid to
minute,
leave.
wait a minute, wait a minute. I'm trying to help you here. If you want the repairs done, they have to gain access to the property.
Yes.
So do we have a date for them to come in and effectuate the repairs? He says September 29th.
September 29th.
And she would leave on the night before, because we'll be there in the morning. We've already make the arrangements for the whole week for her to be staying at the hotel. We'd even change the location to make it more convenient and a newer.
Is that okay?
Yeah.
So you're agreeing to leave on the 28th of September and remain in a hotel until what, about the 5th of October?
Give or take, yes, Judge. That was their projection. And there's one additional.
Wait a minute, wait, slow down. I don't want to hear give or take. I'm not writing give or take in an order. Tell me how long it's going to take, and then she can agree to leave during those days, and you guys can have access to the property.
The contractor assured us it would be done by that Saturday, which was October 4th here. Let me look here.
So you're going to put them up in a hotel until the 5th?
Yes, absolutely. She will not be out 1 cent from that. We will make the arrangements for her. We're required by HUD to provide that to her.
Okay, so I want to make sure this is okay with you. September 28th, the night of you vacate,
Okay.
right?
Yeah.
You come back on the 5th.
Okay.
In what hotel? I want this all in an order.
It's a proposed consent agreement. It is located off of North Line. It's the new Detroit Townhouses, I believe is the name of it. We've given her the information before. It was Judge Hessen's suggestion. It was a newer location.
Well,
Do you know where? Do you know where?
Well, there was like 2, and, last I knew, there was 2 different ones.
I just want to know, do you know which 2 they're talking about?
No, North Line, Detroit. I thought it was on Eureka.
It may be Eureka. It's over by 75. It's right there off 75. It's a new place. I believe it's a Marriott Just it's on the south side of the road. We'll send her an email, Judge, Your Honor, and if we get done before, we'll be happy to let her
Can I
know.
put this in an order right now, and then I don't have to worry about this? This is so incredibly petty with so many things going on here. I want the hotel listed. I want the order saying she's going to leave the property to allow the plaintiff to effectuate repairs, which consist of A, B, C, D, E, and F, or whatever they are. And then that she's going to, the plaintiff is going to pay for and relocate her and her family to the hotel at the Marriott or whatever it is on whatever street in whatever city in whatever state.
We can do that. It's already in the order. All I gotta do is cut and paste, and I get it to you this morning.
Pull out your order. I have a feeling nothing's going to go right on this case. If Judge Hessen, if you guys were not allowed access to effectuate repairs, I mean, look, I'm not going to babysit here. I'm telling you right now, I am not about to babysit. That's ridiculous. She wants repairs. She won't let you in. You guys go in, douse down, being told people are stealing things. I'm telling you, I am not going to babysit. So put it right in your order. Pull out the conditional dismissal and tell me what we're adding in that order. And then I'm going to order it, and then there's not going to be any problems. And if somebody doesn't let somebody in or somebody doesn't show up with the contractor, there's going to be a serious penalty.
Yeah. So there are three portions of the repairs. The first one requires a contractor and her removal from the property or family. That's the one we're talking about starting September 29th. There's also a flooring issue in the kitchen where the tiles are starting to pop up. That is something that would be done internally. They do not have to be displaced for that. That can be done anytime from now until the 29th. All we would need is her cooperation.
All right, then you're going to put it in there. The flooring will be repaired on or before September 29th. Defendant / counter plaintiff shall provide contractors hired by plaintiff to gain access for the purpose of repairing the kitchen floor. What else?
The other will happen after, when they'll do painting and they'll do the what they call it, finishing work after the contractor.
When's that going to take place by?
That'll be right after the work that's done.
Let's say by November 1st,
Sure.
Plaintiff shall paint the residence wherever it is, whatever walls, whatever portion of whatever wall, maybe the 13 inches and 1 foot on the east wall, the north corner, but then don't paint anything else. You put this all specifically in an order, and I want it on here right now, please. I'm not going to go through this. This is nonsensical garbage as far as I'm concerned.
I agree.
I mean, you guys, I thought had an agreement, and I'm getting motion after motion, and I'm not gonna babysit. They don't pay me enough to babysit.
I agree.
So let's get the order. Let's put all the language in here, because I have a feeling when you submit the order, there's going to be an objection, and I'm going to have a hearing, and you're going to be in Italy, and then we're going to delay this, and I'm not delaying it. We're moving forth on this. So tell me. In fact, I want you to draft the proposed order now.
I'm working on it, Judge.
And I'm not, Ms. Mount's not leaving until she looks at it and she approves it, and I'll sign it. You're going to send it to Jen. Jen, tell them where to send it.
Mr. Gallup, you can email me that at jen@33court.com.
Okay, Your Honor, I'll have it to you within the hour, probably within the next 20 minutes, actually.
Thank you very much. And then Ms. Mount, we're going to print out the copy of the order. I want to see it too, Jen. So when you give her a copy, I want to see a
Yes,
copy.
I'll print a couple copies and bring them down as soon as I get
Thank
it.
you very much. Thank you.
Judge, if I may, before though, they go, what time on the 6th for these motions? Do we want to do the afternoon or late morning?
What day of the week is that?
It's a Monday.
Well, I probably have sobriety for it, right? Don't I? Let me think. 25th, 8th, 22nd, the 6th is a Monday.
And there it is. After endless filings, emotional accusations, and repair delays, the judge finally lays down the law. Access must be granted, repairs must happen, and any more obstruction could lead to penalties. It's a clear message. The court won't babysit chaos. This case reminds us how fragile settlements can be when trust breaks down. What started as a housing dispute turned into a legal marathon. If you found this courtroom roller coaster as wild as we did, hit that like button, Share your thoughts below and subscribe for more jaw-dropping courtroom breakdowns. Only on Courtroom Chronicles.
Anthony Jordan Urso. Call him Mr. Baldwin. 25R 252 5580M.
Welcome to Courtroom Chronicles. Today's case is one that'll leave you speechless. A man stands before the judge for assaulting someone he once knew. But here's the twist. The victim is in a wheelchair. The tension rises as the defendant tries to apologize. The victim stands firm. And the judge? He's not having any of it. Stay tuned. This one turns emotional, fast, and it's a powerful lesson in accountability.
Stay right there if you would, please, until your lawyer comes in, okay?
Yeah, George needs him, yeah. I don't think so. No, it's fine.
Good morning. I called Anthony Urso. Sir, your name.
Attorney Mike Baldwin, House Counsel, P 65417, on behalf of Mr. Urso.
Sir, your name.
Anthony Urso, Your Honor.
All right, sir.
Judge, today is the date time set for sentencing. Just bear with me here while I pull up my report. We have gone over the pre-sentence investigation report. Judge, we announced that there are no deletions, corrections, errors, or omissions in this report, Judge. We're asking the court to adopt the recommendation. I believe this was taken under the deferral statute related to A and B. And he is gainfully employed as a laborer. He has no more past criminal history. He's in good health. He's not on meds. So I'm asking the court to allow him an opportunity to show the court throughout the probationary period that he can satisfy his terms and conditions and be afforded the opportunity for dismissal.
Sure, I'm Michael Lanitsberger here. Michael Lanitsberger, either here or
Here.
come on up here, sir. Yeah. John, go help him, will you, please.
All right. You want us to stay here or sit down?
No, you're good. What's your name, sir?
Michael Thomas Lanitsberger.
I'm glad you came. I'm gonna come back and ask you if you have anything to say here momentarily. Is there anything else that you would like to say, Mr. Ball?
Yes, this was a bond condition for my client not to have contact with this person. And I have reason to believe that my client would like an opportunity to apologize on the record in open court when he did not want to violate his bond condition by having contact with him. Is that correct?
Yes, yeah.
And here it is, the apology moment. Anthony turns to his victim, Michael, and admits he slapped him. But let's be real. When someone says, "It wasn't me to do that," that's not full accountability. What do you think, viewers? Is this genuine remorse or just courtroom damage control? Drop your thoughts below, because this kind of half apology often shapes how a judge sees your character.
I don't have a problem.
Go ahead and apologize.
I would like to apologize to you, Michael, for what I did on the incident of the day.
What did you do?
I slapped you in the face. It wasn't right of me to do that, and I wasn't thinking clearly. I hope you forgive me.
Would you like to say anything, Mr. Ansberger?
Yeah, I think he's somewhat a little bit dangerous. There was absolutely no reason for this. And I probably would have let it go, but after he so-called slapped me, which was more like a punch because I've got black and blue marks pictures that I can show you. And also I was watched for a possible brain bleed because I'm on blood thinners, okay? But he just took off, he jumped in the car, rolled the window up, threw my bag, I carried my stuff in, out and took off. Now, he would have come around, said, hey, I'm sorry, would have been a different story. This man has a pistol, okay? Legally, whatever. I just think he's a little bit dangerous. And flies off the handle. This is not the first time. He trashed my office once. He didn't like the work or what. I'm giving him, his two other brothers, jobs and all that. We have stuff still missing. Can't say it was stolen, but it's gone when I had it, when he was working. That's about it.
Anything else?
No, that's it. I'm a pretty easy guy to deal with. I was a probation officer for 20 years myself.
Where?
Livonia.
Judge McGann and Brzezinski?
Brzezinski.
Very good men. Very good, very, very, very good men. Very good judges.
Pretty well known in different facets of the legal system, so
Well, I'm glad you came. Is there anything else you want to say, Mr. Russo?
Ma'am, Your Honor, we're asking for HIDA. HIDA requires that the individual make an admission and that.
You already, the prosecutor already agreed, right?
I agree. The point that I'm trying to make is my client has some work to do to earn this HIDA. And that is what this court orders him to do. And I trust anger management or a component thereof will be a part of that HIDA process to further assist my client as a younger individual in how to handle his matters when he's socially interacting with other people.
I don't know how to put this delicately. I don't know if I'm capable sometimes of putting things delicately. He just struck a man in a wheelchair.
The judge finally breaks his calm demeanor, and this is one of those raw courtroom moments. He struck a man in a wheelchair. Those words hit hard. You can hear the disgust in the judge's voice. He even says, "It doesn't take much of a man to do that." That's not legal language. That's moral outrage. The judge is speaking not just as a jurist, but as a human being. And honestly, who can blame him?
That's so demeaning. So demeaning. It doesn't take much of a man to do that. I say it sometimes in here, and I don't care who thinks what about it. It would be an interesting scenario if anybody who's ever charged with domestic violence or aggravated assault or assault and battery went and picked on one of the MMA guys or somebody who's 6'4", 262 pounds that plays linebacker for a professional football team. And this just this agitates me because you took advantage of a situation. And if he was 6'4", 262 pounds, I doubt you would have slapped him, especially if he wasn't in a wheelchair. So you better take a good long look at where you're going. I appreciate the fact that you don't have a criminal history. I believe what he told me. He's expressed concerns, and I share those concerns. 12 months probation. I'll take it under HIDA. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you attend an anger management program with 8-week follow-up. You're to attend that, complete that. You're not to enter 32823 4th Street in Rockwood. You're not to have any contact with Michael Lansberger. Cannot write, phone, see, text, email, or communicate with him, or have anybody else do any of those things for you or on your behalf. You're not to possess any firearms. You're not to possess dangerous weapons. If you have any firearms, he just said you did. You are to surrender them immediately. and go talk to the prosecutor in Rockwood. He's here still, and the lieutenant, and tell them when you're going to surrender their firearms and how you're going to go about it. Do you understand that?
I already surrendered, when I was given the first court date.
Okay, where are they now?
They're in either Rockwood or Gibraltar.
Okay. All right. No firearms, no dangerous weapons, no contact. Don't go back to 32823 Fort in Rockwood. Anger management with 8-week follow-up, 3 days court work. There's a $35 a day charge for that for a total of $105. Fines are $100, costs are $125, $75 victims' rights fee, $50 justice assessment, $350. Screening fees $60 for $410. You have probation fees of $240 for $650, attorney fees of $40 for $690, plus you have court work program fees of $105. The total fines and costs are $795. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm going to give you a review hearing date. I expect you to stay on the straight and narrow. When I read he was in a wheelchair, I thought that was not good. It's not that I condone in any way assaults of any kind, but you start assaulting people in wheelchairs, it tells me a little bit. You got something going on up there we got to fix. Do we understand one another?
Yes, Your Honor.
I'll take a review hearing date, Lisa, please.
August 27th at 9 o'clock.
August the 27th of 26 at 9 a.m. Do you have all this money to pay or do you need time?
I have this number today. Your Honor.
There's no restitution, right, sir? Everything was covered?
Yes.
$200 now, and you make $500 a week. I'll let you pay.
In the end, Judge Brzezinski sends a powerful message. Remorse means nothing without accountability. Anthony walks out with probation, but his record and reputation carry the weight of that moment. Striking a disabled man wasn't just a crime. It was a character test he failed in public. What do you think? Was this sentence too light or perfectly fair? Let us know in the comments below. And if you found this breakdown as intense as we did, hit that like button, share this video, and don't forget to subscribe for more real courtroom drama every week, right here on Courtroom Chronicles.